Assalamu alaikum everyone, we're now live. I welcome you all to the 6th YGA Legal Conferences. On behalf of the Youth General Assembly, I extend my warmest gratitude to all our esteemed panelists. I would begin the formal session by introducing the Youth General Assembly. Youth General Assembly is an autonomous assembly that has been formed in order to provide a credible platform that instigates the true sense of policy and strategy making, equitable administration, and non-customary legislative public speaking by empowering enthusiasm in youth for being the future ambassadors and democrats. The aim is to inculcate the convening and confronting qualities amongst youth to expand their perspectives and knowledge regarding true democracy and parliamentary politics. The aim of the 6th YGA Legal Conference is to ensure the role of youth as the driving force behind justice and extend its role in creating a bridge between textual knowledge and practical application to empower the youth of today. I would begin by introducing our panelists. Joining us today is Mr. Jawad Sirwana, who is an advocate of the Supreme Court, a member of the Mediation Committee Advisory Board, International Bar Association. Mr. Jawad Sirwana is a practicing Supreme Court advocate, a partner of Abraham and Sirwana, and a UK-accredited commercial and investor state mediator. Mr. Jawad has conducted civil, commercial, banking, labor, and constitutional cases before the Supreme Court of Pakistan. Joining us today is also Mr. Saeed Akbar Hussain, who is the founder of the ADR initiative. Mr. Saeed Akbar Hussain specializes in dispute resolution and practices as an advocate of the High Court. He's an internationally credited mediator, negotiator, and conflict management consultant. He's the founding partner of SAZH Consulting LLP and the ADR initiative, which is the corporate partner of ADR ODR International in Pakistan. He's also the resident representative of ADR ODR International in Pakistan and is one of the only individuals from Pakistan to be nominated and shortlisted for the National Mediation Award 2020. My co-mediator, Eamon, you can have it from now and introduce our two panelists.
Assalamu alaikum everyone. My name is Eamon Aman and I'm a final year law student. I will be introducing our other two guests. So we have with us Ms. Mehek Zarakbari. She is an educationist with more than a decade of experience in legal education. She is the co-founder of ADR Initiative and founder of the Justice Initiative and heads both their think tanks. She is the head of the law at Ivy College of Management Sciences and teaches LLB and LLM. She is a published author and has worked with the World Bank, Amnesty International, and the Asian Foundation. Next we have with us is Ms. Kumar Anwar. Ms. Kumar Anwar is an advocate of the High Court. She completed her LLB degree from the London School of Economics and Political Science LSE in 2014 and was awarded the prestigious Chevening Scholarship in 2017, through which she pursued and received LLM in Corporate and Commercial Law from LSE. She scored 3 distinctions in the Law of Corporate Finance, Fundamental of International Commercial Arbitration, and the Theory and Practice of Dispute Resolution. Thank you. Over to you, Hania.
Thank you so much, Eamon. I again extend my warmest gratitude to all our panelists. Mr. Sirwana has dropped out because of his weak internet connection, and I hope he'll be joining us again. So I would begin by Sir Akbar Hussain. Sir, you're the founder of the ADR initiative. But what I think is कि हमारे audience के लिए आप please introduce कर दें कि ADR initiative है क्या, what was the vision behind it, what kind of services you're providing, and how successful has ADR initiative been to date.
Thank you, Hania and Eamon, and congratulations to the YGA for this conference. It seems like a wonderful endeavor. So as to the beginning of the ADR initiative, it actually started with Jawad, who, when I was very young and very frustrated with the legal system, basically, how did I get it? Once I announced that I wanted something else, I wanted ADR. Someone gave me Jawad's number, and this is around 6 or 7 years ago. I called him, and he encouraged me to pursue mediation to see what is possible and so on. The basic angle or the basic premise behind the ADR initiative is that our legal system, particularly with regards to litigation, has not served the public or has not served the interest of justice as it should have because of our immense backlog of litigation, of lawyers, of judges, of the entirety of the system. Essentially, what people want out of it, which was their disputes resolved in a quick and expeditious manner, was not possible. So we had to pursue ADR, or we had to see how ADR could work. So the ADR initiative began when I basically started my affiliation with the ADR International. I met Rahim Shamji, their founder. I was trained as a mediator, and I asked him to give me the option of bringing the accredited mediation course to Pakistan. So following that, I became the resident representative. I brought the course to Pakistan, and shukr alhamdulillah, I can safely say that now we're the one of the only ones who offer a private mediation course, and we have trained approximately 50 mediators accredited in Pakistan, who then basically handle all sorts of mediations. So our success, I thought, would be that we would do some courses, and then essentially the market would take care of itself. But I was told by everyone involved that we shouldn't stop there, and we should work on, let's say, deeper reforms, from legislative reforms to, let's say, research, think tanks, and also to spread the word about ADR. So essentially, our job now is, or ADR initiative now, is Pakistan's ADR platform for any and everything that you want as far as ADR is concerned. We are very soon about to launch Pakistan's first roster of mediators, which has been created with the support of the Asia Foundation, through which everyone and anyone can, using our website or various platforms, engage, find, and sign with any mediator, schedule anything, and establish the entire process of mediation from start to finish with the ADR initiative. This is a first in Pakistan, and I'm very glad that we got the chance to do this. Essentially, our job is to offer everything that is required to make ADR possible in Pakistan. So because we were told that currently there wasn't a database or a manner in which the general public could engage mediators, sorry, we started with the mediation roster, and shukr alhamdulillah, I can say, well, I can't announce it right now. We have around 6 or 7 MOUs with various organizations, but we have some substantial partnerships coming up with the entire corporate world, which is going to be using the roster for the entire dispute resolution package. So let's say, which I think I can safely say at least this much. A lot of companies in various sectors of the field, from power to banking to telecom and so on, will soon be engaging mediators for every and any dispute that they'll be involved in, because we pretty much been in conversation with them, and that is our job, to help area practitioners find work, because if that becomes a possibility, then area will become mainstream, and if area becomes mainstream, then we've done our job and I can relax. So that's pretty much it.
That's a great initiative. Ms. Mehek, since you're also the co-founder of the ADR initiative, how do you assess the current scope of ADR in Pakistan? Very unfortunate that Ms. Mehek, you're lagging. There seems to be some distortion. Ms. Mehek, we can't hear you. Ms. Komal, can you hear us?
Yes, I can hear you, Hania. If you want, I can take over from there.
Yes, Ms. We'll want you to respond in this first, and then we'll move to Ms. Mehek once her internet is restored. Thank you.
You're most welcome. So my story starts from the fact that when I graduated from LSC in 2014, and that's when I started working, and I realized that there were a huge backlog of cases in court system, and at that time I wasn't really exposed to ADR, but my one of the cases which my senior gave me was to do with arbitration, and I was fascinated by studying arbitration, and I got to know for the first time that there is something called arbitration, an out of court settlement, which is more efficient than litigation. So thereafter I went to LSC to specialize in arbitration, and then once I came back, I was fortunate enough to be exposed to both domestic arbitration and international arbitration. So what my experience of arbitration is that although it provides fantastic benefits in comparison to litigation, such as neutrality and efficiency and confidentiality,
Because if, for those of them who are not aware of arbitration, I'll explain the definition of arbitration, which is very simple. It's basically when a dispute arises, the disputing party appoints an arbitrator or more than one arbitrator with who is a completely neutral party to settle the dispute, which means that instead of going to the court, you give the matter in the hands of a neutral third party to decide the dispute. So, if the sanctity of arbitration is kept intact, meaning that the parties to the arbitration do not curtail the process of arbitration by sort of, delaying, adopting dilatory tactics, taking adjournment similar to litigation, then I think it's a very useful dispute resolution mechanism, because it provides, number one, efficiency. Unlike court system, it's not like the arbitrator has to take care of a backlog of cases in order to determine the decision of the dispute, and it provides confidentiality. All the arbitration things are completely confidential. And as far as the costs are concerned, it's a bit debatable sometimes. If there is LCIA, which is the London Court of International Arbitration, which if it conducts arbitration proceedings, sometimes it can be very costly, but in comparison to litigation, in most of the occasions, arbitration is much cheaper in comparison to litigation. So my experience overall in Pakistan has been that often at times, especially in Pakistan, the retired judges become the arbitrators. So instead of appointing the retired, opportunity should be given to newcomers as well, young lawyers as well, to become arbitrator. And unless that opportunity is extended, I think it's very difficult to give motivation to youngsters to step into arbitration, because ultimately there would be very limited exposure to them to eventually become arbitrator. So that's my overall summary of the way things are when it comes to arbitration in Pakistan.
Yeah, that's absolutely an insightful experience. Ms. Mehak, if you can hear us, you would
I
want
can
to.
hear you.
Perfect, absolutely fine. So, what would be your
Okay.
take on this? We're very looking forward to hearing you as well.
All right. I was trying to fix the mic us वक्त से. Your initial question, as I recall, was that the scope of ADR in Pakistan. All right.
Yes.
As your other moderator, Eamon, has already stated that I'm an educationist and I have been in the education industry for more than 10 years, I'll be looking at from a point of view other than Komal's, who is a practitioner. So I'm looking at from a point of view of education. When me and Akbar met, he started off with courses. And these courses, even though they are slightly more expensive because they are accredited and they are delivered by a foreign faculty, people thought that they will not be well suited for our community, but people still did do those courses. However, I do understand that they are also foreign courses, and most people who are in the industry might not be able to afford them as well. So, because of that, we are also in the works right now to make a local diploma for ADR. Furthermore, when we're talking about ADR, right now I'm the head of law at Ivy College of Management Sciences, and we're offering an LLM in conflict, dispute resolution, and commercial litigation. There is a huge number of students for LLM who are interested in ADR, because if we look at the local and the foreign syllabus, ADR might be just for the University of London one module, but the local degrees do not offer any module on ADR for the LLB. Therefore, they are now more interested that how do we get into this new and upcoming area of law, and they want to know more about it. Like, for example, arbitration right now, even for practicing lawyers after their LLB, it seems like a very attractive field as well, and not just litigation, because it is something that they feel is more lucrative. Furthermore, because everyone knows that our Pakistani legal system, there's a lot of hurdles, and the cases they do not, get decided in a given time period. So Therefore, lawyers themselves are also getting frustrated with the system, and they want to have those skills of negotiation, mediation within their uh, skill knowledge, so they can also be able to facilitate their clients in a much better way. Furthermore, if you look at our culture is a culture which is based on different modes of ADR. Um, Litigation, yes, is a formal mode of resolving dispute. But if you look at, for example, in our culture, that the head of the house makes a decision, or people go to the Malvi to have, an insight or a decision or, some advice. Those are different ways people do seek mediation. सुलह सफाई वो करवाते हैं. So it's a very much part of our culture, and people are attracted towards it. So I would feel that right now there's a lot of scope, and I'm seeing that with my students as well. More and more are opting for it. More institutions are coming to the ADR initiative because they want us to make ADR centers in their institutions as well. So that's my take.
Absolutely, a huge change. We're seeing see change ourselves, because in our law school also there's a functional ADR center going on, and so many students are affiliating with it and they're benefiting from it as well. Sir Jawad, if you can hear us, what would be
Yes,
your take?
yes, I can.
Perfect, absolutely fine. Sir, what would be your take?
So I think we've managed to come some distance in ADR, but there's still a very long way to go. When I sit here on the practitioner side, and I'll speak from a practitioner's perspective, I get very few referrals on mediation. And even when you look at the arbitration spectrum, there aren't many arbitrations taking place domestically and internationally. It seems that people are still quite unaware of the efficiencies and the advantages of these two modes of dispute resolution. So, unless and until you get the message across that this is something that is faster, quicker, better than litigation, I'm not sure how much traction we'll get on ADR. So at the moment, it's still a struggle, and let's just say it still doesn't help the kitchen run if you're talking of mediation. And even on the domestic side, when you're looking at arbitration, it's remarkable that most people, when you think of an arbitrator, think of a retired judge. And so what happens is that a lot of good lawyers who are equally good arbitrators, there's Komal here with us. So Komal is a young arbitrator. Now, there is no reason for Komal not to be available to arbitrate. But the general stereotype amongst the public is that an arbitrator has to be an old man with gray hair. And they need to look at Komal and see that this is an equally competitive and efficient alternative there. Of course, I shouldn't miss out Akbar and Mehak either. Otherwise, they'll say you're sending off all the work to Komal. So let me add Mehak and Akbar in that too. The point is that here are young people, competent, qualified, but the whole system of arbitration, the way it's set up, abroad it's slightly nuanced different. It's the white Anglo-Saxon male, and in Pakistan it's it's predominantly old male dominated. So that's my kind of general comments on ADR.
Actually, great. So, as all our panelists reflected that the various modes of alternative dispute resolution are efficient, cost-effective, and more importantly, confidential as well. So, Sir Akbar, I would like to ask that how can ADR assist our civil justice system, given that there is a huge backlog of cases? So, how do you see ADR assisting the different modes of ADR assisting the civil justice system in Pakistan today?
Dekho, we can scale it back from, let's take arbitration, which is the closest thing that they have to litigation, right? So just arbitration itself, for example, अभी यहाँ पे हमारे ऑफिस में ही पिछले कुछ देर से हम लोग एक arbitration कर रहे हैं, and that arbitration compared to a trial that happens in the civil court is miles apart from the time and the efficiency that it takes, right? So when we were, I was training the Punjab Judicial Academy, and unfortunately, there's still that perception that, like Jawad said, you have to find the retired judges, and even amongst the judges that are currently being brought into our industry or that are being enrolled for the commercial courts which we were training, a lot of them are averse or somewhat hostile to the idea of ADR because they don't seem to completely, let's say, understand or buy into whatever it offers, right? So this particular judge, he asked me, sir, I was basically giving a lecture on ADR mechanisms that are available in various legislations. The Commercial Court Ordinance has it, your CPC has it, you have a Punjab ADR Act, Sindh has 89A, 89B. Jawad was instrumental in making that happen. KP also, Samba, we all have our acts that say that when this case comes to the civil court, it must be referred to ADR, and these are who can handle, these are the people, the neutrals, everyone has a different language for it. The question was, what happens after the case has gone to ADR? And maybe let's say, and by ADR I mean mediation right now. Arbitration ka to ek simplified hai na कि arbitration makes the trial smaller, more efficient, more compact, and you're left with pretty much very limited grounds of appeal or even dismissal for that matter. The mediation angle was कि अगर आपके पास एक settlement आ गया, the judge साहब asked me कि इसको पे कोई appeal कर सकता है, कोई challenge कर सकता है? And my default response was, sir, everything is challengeable in this world right now. तो appeal तो कर लेंगे, लेकिन उसके ground आपके पास क्या इतना, sir? What ADR does for the civil justice system is it reduces what the civil justice system has to do for that. Arbitration reduces the requirement to have a trial in the judge's court. Trial यहाँ पे होता है. जब यहाँ पे एक दफा ट्रायल पूरा हो गया, एविडेंस रिकॉर्ड हो गई, सब कुछ एक जजमेंट के अंदर शामिल हो गया, ये अब जज ने खुद बैठे अपने चेंबर्स या अपने कोर्ट में नहीं करना. उसने सिर्फ ये देखना है कि जो जो एविडेंस आई है और उस एविडेंस के ऊपर जो जो एक लेट्स से अवार्ड आया है, इज दैट accurate? Does that reflect the law of the land at the moment? If it does, then you'll make it a rule of court and that will become binding on the parties. The civil justice system has absolutely no issue with ADR, and it cannot really have an issue with ADR because ADR is meant predominantly to assist the courts or assist the civil justice system to reduce the requirement for the judges, for the entire judiciary, for the entire benches, for the lawyers, for everything else to be, I'm not going to call it a burden, but let's say if we actually do try to quantify the amount of judges we need to handle the cases, we need at least 4 times the amount of judges we currently have. You don't have the budget for any of these things. You don't actually have the cost or the funding for any of these. So what do you have to do? You have to let the ADR, the mediators, the arbitrators do their jobs, which essentially means that if a case does come up, which is a very basic, simple case, कि dispute ये है और इसके ऊपर ये issue है, हमें इतने पैसे चाहिए, and so on. Judge ने उसके ऊपर कोई नया law नहीं दे देना. There is, आप damages के ऊपर जो है नई interpretations नहीं आने वाली कि आप this is how you quantify damages, this is how you come up with whatever's going to happen. Liquidated damages के ऊपर हर arbitration का case होता है. हमारे पास सब रट गई हुई हैं कौन सी हमने citations रखनी है सामने, क्योंकि अब उसके ऊपर कुछ खास changes नहीं आने वाली. So the judge sitting, the High Court or the Supreme Court or the civil judges, they're not really going to sit and interpret the law anymore. They only have to apply the law. And if there's only the application of the law that has to happen, then that can be done by anyone remotely qualified to understand this is the law, this is its application. It's, they say that, and they do, unfortunately, that artificial intelligence is going to replace lawyers by the truckload. That is what they mean. It's really just maths. So you really just have to say, this is a dispute, this is a problem, this is how it applies to the situation, hence judgment. That is what the civil justice system needs from ADR, and that is what ADR should provide for them. Disputes should never get to the courts. Disputes can and should always be resolved long before that. The court should only be available for a legislative or a legal or statutory interpretation. उसके अलावा उन्होंने कौन सी कोई नई चीज देख लेनी है? So our job is to basically assist the civil justice system to simplify and to just get all of the important dispute resolution, yeah, dispute related facts completely clarified, and let the judges just do what they do best, which is enforce them. If in an ideal world.
Yeah, seems quite idealistic right now that disputes are not being taken to courts. Madam Mehik, my question would be that since Sir Akbar also rightly mentioned that there's a lot of hostility towards area processes and mechanisms at the moment, I believe that academic opinions help build narratives. So, you being an academic, how do you think you can be instrumental in changing the narrative around ADR?
Thank you for that, Anya. I did a research paper which right now has not gone to publication, but it is on basically the past ADR landscape in Pakistan. And most of the information from data collected goes towards two concepts. One is supply, the other is demand. Now, the demand for ADR is there, as we've already looked at cultural aspects and aspects of people, as you said, the cases take so long, and not every case as well is suited for litigation when you want to have existing relationships and other contracts still to be fulfilled. Litigation is still not the best path, or you have family law cases, litigation is not the best path. But the problem is very practically that our supply of ADR practitioners is limited, and we have a lot of lawyers. And lawyers do feel insecure when their territory is being encroached. So, in order to make sure that our supply of lawyers are also on board, there should be ADR training mandatory at the level of LLB, basically. So when they have that training, they will not see it as, someone's taking our bread and butter. Why are they not going towards the court? Why should we go towards mediation? Those questions should not come into their minds. They should be trained, they should have the skill set, and they should be presenting that as one of their skill sets. That this is something I can offer as well. Now, with arbitration, because people or students see a lot of money, they, are all for it. With mediation, because it is not something which is court enforced, or even if it is the court elects mediation, it's a very small percentage. If we look at the model of Turkey and how Turkey started off their mediation in employment law, they made only one session of mediation necessary in order for the case to go to litigation. So the employee and the employer, or whatever employment dispute there was, in Turkey, the person still had to go for one session of mediation. And it was a free session of mediation that was being paid by the court. What Turkey realized was that when people do take that one session of mediation, they go towards it. So first they started out from labor employment laws, then they expanded different other areas of laws as well in Turkey that would, go to mediation. And that one mediation session was compulsory. In Pakistan, I feel that if it is made compulsory, even that one session, and if our judges and our lawyers do not feel insecure, I think that is the path that might help ADR be more mainstream.
Yeah, I mean, I would agree with it that there has to be an introduction to alternative dispute resolution, at least at undergraduate level. So when we have our lawyers, our law students joining the field, they at least have a know-how of how ADR goes about. So, Eamon, since you've been here for quite a long time, and if your internet is stable, you can take the.
Uh, can everyone hear me?
Yes, we can hear you.
So my question is with Ms. Mehik. Ma'am, you just mentioned that we have seen that mediation has been, a good resource, or mediation is, usually used for family disputes. And it says that litigation ki taraf na jaye whenever you have family cases, because, there are less chances of reconciliation. So do you think that mediation, one of the methods of ADR, is a better or effective tool for family issues these days in Pakistan?
In your laws, you're supposed to mediate. You have 90 days of iddat. The Union Council every month is supposed to send a notice to both parties to come on the table and mediate. Either they take it up or the Union Council doesn't send those notices. I understand that the dispute is between a man and his wife, right? But the children often become collateral damage. When you go through a system of the courts where nothing is then confidential, your family history is dirty laundry, everyone is you know fighting and reputations are being sullied, it's the child at the end of the day who's going to suffer. It's the minorities who are going to suffer. It's the people who have less power. Women generally, they suffer in the courts as well. They don't want to go through people staring at them. There's a taboo of divorce in our society as well. Because of all of that, mediation, taking the best interest of the child, looking at the power dynamics, because someone might be able to afford a very, expensive lawyer who's very powerful because the husband might be the one making the money. The woman might not be able to do the same thing. So therefore, mediation going forward is one of the good things, because if you still have children, it's better for the children that the parents also have a good working relationship. Now, with family mediation, they are proper courses where mediators are trained in family mediation, and they have to also keep in mind the laws of the country when it comes to child rights as well. So, therefore, if they are implemented properly, keeping in mind human rights, keeping in mind child rights, I think it is one of the best ways to go rather than going through.
Thank you very much. Ms. Komal, would you like to add anything to this?
Ms. Komal, can you hear us? I think she's having some internet issues. Her video is also stuck, and I did see her dropping in and dropping out. Maybe Ms. Komal, you can reconnect if you can hear us. So, Mr. Savannah, I'll move to you. So, as Ms. Meg reflected that in family law cases, we of course have a particular aspect of repute involved. Some family matters need to be resolved in a private setting as well. So confidentiality is an exceptional feature of alternative dispute resolution when it comes to family law mediation. So how do you assess mandatory mediation? Should mediation be mandatory?
Right. I think to get to mandatory mediation, you need to do a lot of capacity building, because look at the number of cases filed per day and given a year's worth of cases, right? Litigation. If you are looking at mandatory mediation, who's going to mediate, right? So you must have a capacity within the city or the country, more so the province now after the 18th Amendment, that you can actually have a capacity to entertain referrals, especially if they are mandatory. Because if you do not have the capacity, or if you have the capacity and qualitatively there are some issues with what's coming out through these mediation processes, then it's going to make everyone unhappy and mediation may not survive. So, in order to make mediation mandatory, before you get there, there needs to be a lot of capacity building. Akbar has started capacity building with his institute. Over here on the side in Sindh, we have the Pakistan Mediators Association's mediation training program, but that's not enough. If you're looking at the province of Sindh and Punjab, 2 or 3 institutes will not be able to meet the level of training. And then the other aspect is that once you're trained, the work takes time. So if you make mediation mandatory, by the time the work starts trickling in, that trained mediator may not have had the opportunity to mediate and lost his or her skills. So I think it's a good idea, but we still have some time to go before we can reach that point of mandatory mediation.
Yeah, a very strong point has been indicated by Mr. Sarvana. He says that capacity building is very important before we actually make mediation mandatory. Ms. Komal, if you can hear us, your comments on this would be very valuable for us. How do you perceive capacity building in the ADR processes? Ms. Komal, it's very unfortunate that we cannot hear you. She's dropped out, so she'll be reconnecting anytime soon. So, Sir Akbar, I'll shift to you. Your initiative, the ADR initiative, has been working a lot on capacity building. What are the hurdles that currently you people face when it comes to inviting people to mediation, or to when you invite students to come and train as mediators? Is there any reluctance, or what are the issues?
So, like Jawad said, it's a chicken and egg situation. If there is no work, then why are you doing the training? And if there suddenly turns out कि इतना ज़्यादा काम आ गया, like Jawad said, let's say we make mediation mandatory, then no one's trained. And maybe what has most likely happened in quite a few moments, certain untrained people then basically try to mediate, and their mediations may or may not be successful, but it's due to their lack of training. The chances are that it may not be successful, it may not represent the sort of mediation that maybe Jawad or I are talking about, where the mediator is neutral, where everything's confidential, where you're not really concerned about integrity issues, about sharing of confidential information, and so on. So, what we've seen, first off, when we launched the course, the first, let's say, what would be the word? The first hurdle that we felt was one of price. The second hurdle was one of credibility. So when we had to tackle credibility, we had to figure out when we had to tackle credibility, we had to bring, let's say, ADOD International into the sphere, right? ADOD International has, mashallah, the most accredited courses on the planet. We have Civil Mediation Council in the UK, Singapore, and the International Mediation Institute. Now, all of that demands what, let's say, ADOD International would want in the UK, which is around £2,500. £2,500 is not feasible for any student, let alone a professional in Pakistan. So we had to subsidize the cost. Even with the subsidized cost, it's still a difficult sell for some people when they don't see the work at the end of it all. So the bigger issue that we're dealing with is, currently, as far as the initiative is concerned, we have to show that we have to show a number of, we now, mashallah, have an advisor pool that goes beyond 30. We have to show organizations that are interested in mediation, that want to engage mediators or individuals. And then we have to show that these are the people that we've trained. So first, yes, the training was required. We needed, let's say, the minimum amount of mediators in Pakistan to be able to say, okay, mediation is now possible. Now we are dealing with creating the infrastructure for their work to come out. So capacity building, unless it happens at a much larger scale, where, let's say, maybe the judges or the judiciary system, as soon as it announces mandatory mediation, also announces the plan to build the capacity of all the mediators, lawyers, whoever else wants to mediate. But then becomes the second problem that Jawad hasn't mentioned or has mentioned. We are 2 or 3 organizations, right? We have a certain limit on our trainers as well. There's only a certain amount of actual master trainers in Pakistan. So even if we bring them, like we brought the faculty in from UK and Greece and so on, that is still a substantial cost. So it's the point right now we're at is someone has to bear all of that cost, whether the government or the development sector or us private parties, to actually move mediation from the very steep hill it's on. So we push, the hill sort of becomes a little less unforgiving. And then we slowly show that all of this effort has come somewhere. And then the capacity building demand will rise exponentially. The trainers will want to train. there will be institutions. I would love more institutions other than me. I would love competition in the market to actually train people, because that essentially shows that that the economy of it is flourishing. So if it's just us three, that would maybe symbolize that there's not enough work, there's not enough business. If there are a lot of people doing this, then suddenly it's clear because the private sector definitely wants it. They just don't know how or why it or in what capacity it works. So I can't tap into every single corporate client or even a personal client in the market. Jawad can't as well. We're working with the Bar Council, working with anyone possible to spread the word that this is a possibility. And as Mehek mentioned, lawyers are now coming around to it, but the perspective change still is taking time. So first, the students wanted to work in these law firms, and these law firms there are very few law firms in Pakistan right now that actually offer mediation as a practice. So I'd rather have the law firms that offer mediation as a practice, because that is your standard way of doing it. Hence, the capacity demand for it would increase, and then let's say the economics of it all would work.
Thank you, sir, for your response. Ms. Mehek, our next question would be from you. So we've talked about negotiation, we've talked about mediation, and there has been a slight indication towards arbitration as well. So could you enlighten our audience about the other modes of alternative, mainly online dispute resolution, since it's a relatively new thing?
Online dispute resolution is basically you can do mediation or even arbitration online through online means, like you can use Zoom or Microsoft Teams. What that requires is a few more skills, which are technical, which is also thinking a few steps ahead. Because if you want to keep something confidential, don't share things in the chat to everyone. Share it individually so the other party, if has shared something confidentially with you, you do not share it with the people you're supposed to. So ODR is online dispute resolution. It basically, with Akbar and the ADR initiative, we also have developed the online dispute resolution model rules. And we had more than 32 consultants from all around the world who weighed in on those rules. And they basically weighed in on what type of confidentiality clauses should be there, how, if it's online, how would they choose their mediator? For example, how would they gauge when to meet, who should be the focal person? So all of these different aspects are going to be there on online dispute resolution. When we're talking about the COVID-19, because of the COVID-19 and because most litigation court systems are not online, there are a few abroad, people have gone towards ODR more in the past 2 years.
Ms. Mehek, do you want to say something, or is there any distortion? That's why you've stopped.
No, I think I'm done, but yes, there is disruption. So my thought process was interrupted.
Oh, really sorry for that. Ms. Komal, can you hear us right now? No, we don't seem to hear Ms. Komal. So thank you very much, Ms. Mehek, for your response. Indeed, with the pandemic right now, online dispute resolution is something that people have resorted to. But then again, there are issues of confidentiality and technical training that actually serve to be an impediment in online dispute resolution, basically gaining a lot of scope in Pakistan. Sir Jawad, I would move to you. So our audience would really like to know, what are the career prospects in ADR? Not just nationally, but internationally also, if you could just enlighten our audience about the career prospects.
All right. I see Komal there. Komal, can you hear us? No. So I think Komal, let me start with ADR means, right? Arbitration, mediation, and conciliation. So let me start with arbitration. I think when you're looking at arbitration, it can be a great career prospect. And for the moment, while it may not be so in Pakistan, if you're looking at arbitration beyond Pakistan, it's a very well used mode of dispute resolution. There are fewer cases filed in courts than arbitration. So, arbitration is really thriving in the West, not so much in Pakistan. But equally, then it gives an opportunity for training and development. So, this is a great place to be if you're looking at arbitration beyond borders. And the way your development is structured, it doesn't have to be the case that you need to attend a university. You can actually get accreditation from different bodies that train and gives certifications for arbitrations. So there might be the LCIA, there might be the CIARB, there might be SIAC, the Singapore International Arbitration Center. There could be, I forget the current name now, but the old name was the Kuala Lumpur Regional Arbitration Center. So there are many institutes that offer arbitral trainings, and you can do it online, and you can also do it face to face, I guess, once the COVID-19 virus subsides. So the pathway for arbitration is quite clear, and it gives you your return on investment. The other method is mediation, and I think I don't want to repeat the things that Akbar and Mehak have already talked about. So that one is a more of a challenging issue. And finally, you have conciliation. Now, this is really curious because Pakistan law and Mehak has touched upon this in the family law paradigm. In Pakistan law, there's already processes provided for conciliation and mediation. And so Mehak's pointed out the family law, but if you look at the Industrial Relations Act in all our provinces, every time there's an industrial dispute between the union, there is a mandatory mediation process. It's called conciliation, right? So there is a fine difference between conciliation and mediation. In mediation, the mediator does not give a decision. In conciliation, the conciliator gives a decision. So almost like a judge, but you can go back and forth. So when you're looking at conciliation, there's tremendous potential for going into tax. There's tremendous potential for going into labor law. But again, the people who sit on these boards, they're not familiar with conciliation or mediation. So those who are looking into and see the law, maybe they're reading labor laws at the university level in Pakistan, or coming across it and say, hey, look, there's a provision for conciliation. Or they're reading the income tax ordinance and they say, oh, look, there's another process mentioned, mediation. None of those people who sit on these boards, they do much. And so it's an institutional problem of how do you get people who can actually do conciliation, who are trained to run a conciliation process, to be on the right side of the table. So these are, I guess, in brief, the career points. And we really missed out Komal, so we should go back to Komal and see what she has to say on the arbitration side.
Yeah, even I would. Miss Komal, can you hear us now? Miss Komal, am I audible? It's very unfortunate that Miss Komal couldn't join today. Yes, Miss, now we can hear you, but your voice is breaking. Miss Komal, we still can't hear you. We could hear you initially, so maybe you could try reconnecting. Okay, till then we'll move to Akbar. Sir Akbar, Mr. Savannah gave a very comprehensive response to the career prospects for professionals in ADR. What about students? Do they have any prospects of undergoing any trainings maybe? So what is that? So you're on mute. We can't hear you.
Sorry. So, of course, any student who's interested in any training in ADR is more than welcome to do any of our courses. Uh, So essentially what happens is when students do any training of any sort and immediately look for opportunity, you have to figure out what your expertise is in a certain area, right? So you do a mediation course, and let's do arbitration. That's much shorter. So as Jawad said, for whatever reason, Pakistani market doesn't accept the possibility of young arbitrators. It is unfortunate. I deeply have some reservations about it, and I have had some conversations about it with various people in various organizations because, see, there are dispute amounts of every nature. And some disputes are, let's say, of a very small nature, which could be arbitrated by someone young who has, let's say, less experience, but still may be more suitable to the amount of money you want to pay to an arbitrator to make it happen. That said, what I would say more prominently for students who are interested in ADR would be uh, having been, let's say, qualified to be a mediator through any of the courses, ours, Jawad's, or anyone else's. What you should essentially try to target is we are basically launching a young mediators platform, and we are targeting certain areas where, let's say, the dispute amount reflects the amount of risk that may be involved with a younger mediator. So in that sense, there is, inshallah, very soon opportunities arising. They may take from a few months to a year or something, but essentially what on the other side, what I'm enjoying more is a lot of law firms are now accepting or looking forward to our courses like Access CLM and a lot of the other ones as well that we're working with. So they're actively engaging our trainees as interns, as lawyers, as so on. So it's an excellent skill to have in your report. And very soon, inshallah, you'll be able to use your skills as a mediator soon as the market sort of starts picking up after COVID, because honestly, during COVID, things are a bit off. But everyone should still engage in the training of any sort of ADR. I think Komal just joined us, which is excellent timing.
Akbar, can I add something to that?
Yeah, please.
Yes, Miss. We would come to have important questions to ask from you, Miss Mehak. So, just in addition, Miss Komal, can you hear us now? You're still not audible. We can see your video, but you're not. Miss, maybe you'll have to reconnect again. So I'll shift to Miss Mehak. Just like Sir Akbar mentioned that there's going to be a young mediators platform really soon. There's already a Women in Area network that you're heading, and that has an amazing response. So what's the vision behind this, and how do you plan to take it forward? You also mentioned that there'll be a local diploma. So when can we expect that, and what would be the benefits of that diploma?
We are in talks with a few local universities, not just for the local diploma, which will be on domestic arbitration, domestic mediation, etc., but also different educational institutes have our ADR centers. Over there, we also offer them domestic workshops. So if they don't want to engage in months of training, they can do that, like fresher courses in a week or 2 week for domestic mediation, domestic arbitration. We'll be covering Pakistani laws as well as the cultural aspects, because you have to realize that the culture of Pakistan and what generally issues that come up, there has to be culture sensitive training as well as gender sensitive training. Furthermore, you were asking about, and our workshops are going to be starting very soon. Like our area centers who are affiliated with different educational institutes, they're already working on it. Our diploma, inshallah, will be starting within this year as well. We're in talks with domestic universities, but you have to realize they are AGC chartered, so we have to get that as well sorted. Moreover, when we're looking at ADR, women in ADR, Akbar collaborated with Nida Usman Chaudhary, the founder of Learn and Women in Law. Mashallah, unexpectedly, we had a very good response, and a lot of women have come forward that they are interested in ADR, and the group has a lot of practitioners as well as students. We wanted to give a platform to women because in our last talk with the Asia Foundation, Miss Komal was there as well. And Miss Komal, because she's a practitioner, she has also faced a lot of hurdles in litigation as well as, arbitration. She's young, she's a woman, and these issues are very real, and women do face them. In order to see what issues they are, we want to do research with these women, that what are the issues they are facing in these different walks of their profession, how we can overcome them, and it gives a platform to Women United, which strengthens them in numbers. So they become resources for each other as well to, gauge different opportunities, different knowledgeable skills, articles, whatever they want to exchange. Furthermore, there'll be workshops and training, talks. So whatever we are gauging from their input as well to what they want, that is why a platform is made for women. I hope that answers the question.
Yeah, it answers the question, and it's a great initiative, I must say that. Since Ms. Komal has not been able to join us, so we'll move towards the concluding remarks. Sir Jawad, you have the floor.
Thank you, Hania. I think, when you're talking about how to build a practice, how to encourage young folks to look at other alternatives, this is a great step forward. So thank you for organizing this and bringing this together. I think we've had a very fruitful conversation. The bottom line is that there's still a long way to go, and seminars such as this one and a continuing dialogue and conversation will help overcome this concept that, where people are still unaware of the various ADR mechanisms such as mediation and arbitration. But, I am an old man, so just to give you an idea of being old, when I was in college, there were no courses on arbitration in the local LLB program. There were no courses on negotiation. In my old days, which is not very old, but still old enough, the early part of the millennium, students couldn't even attend a class on negotiation, which is a core ingredient of mediation, unless they were attending an MBA program. So something as simple as negotiation, which is a skill set for any advocate, wasn't available to lawyers unless they were looking at a business program for an MBA. And now things have changed. In the last 15 years, the local bar vocational course, or whatever it's called now, they've introduced this concept of negotiation and mediation within their curriculum. So we've come a long way, but there's still some way to go. So thank you again for organizing this and having me here and inviting me to share my thoughts. Thank you, and over and back to you.
Thank you so much, sir. Ms. Komal, can you hear us now? Since we still don't seem to have Ms. Komal with us, so I'll shift to Sir Akbar. So your concluding remarks? Sir, you're on mute.
So, sorry. So, as I was saying, I'm very happy first for the work that you've done. One of the primal things that we did when we started was we wanted to encourage the youth. So the youth is predominantly who we expect to take this forward. हम लोग मतलब जवाब तो अलग बात करें, हम लोग भी अब किसी पिट्ठे बुड्ढे हो गए. So problem that I saw, or I assumed there would be resistance in the youth. That didn't happen at all. In fact, अभी हमने एक internship की applications खोली हैं, and we hired quite a few of them. And the lovely thing I found was almost, मतलब there triple digits में numbers थे of interns who had written papers on ADR or who had interest in ADR from all over Pakistan. और उसके थ्रू ही pretty much हम लोग भी encourage होते हैं कि हम लोगों ने कुछ करना है, हम लोगों ने किसी तरह प्लेटफॉर्म देना है आप लोगों को आगे जाने का. Inshallah, soon we'll develop a lot of things. I understand that you caught me at a moment when in your conference when I have Masha, so many things in the pipeline that I can't really cement on or I can't really commit to. But Masha, there's a lot happening now, and a lot of people have come forward. There are a lot of bar councils, there are a lot of bar associations. Everyone wants to somehow push this forward. And this is a big change from what I've seen in the past couple of years. And predominantly, मैंने University of London ने ADR का course introduce किया था ये मेरे ख्याल से 2 साल पहले, and last year was the first time I taught it as well. And mashallah, my students had 80s and 70s, and everyone is very happy. And suddenly we had an amazing response following that. So the amount of students who are now interested in ADR has exponentially increased, whether because they see it as Agabot cynical or just as a means to a grade, or because they see it as a future. It's beautiful for me to see. So I would love it if you guys continue to keep hosting such sessions, keep doing such conferences, push ADR as a means of having effective dispute resolution. And I'm pretty sure that you will find absolutely no resistance from your parties, from lawyers, from anyone. It's a very thin, let's say, layer of resistance. वो बहुत जल्दी खत्म हो जाती है. और इंशाल्लाह उसके बाद I would very much like to hand it off to all you youth के आप लोग जॉब शुरू करो. हम लोग तो, as Jawad said, we have passed a certain grade now. So thank you very much for this, and I'm very happy that I was able to join. And good luck with pretty much every one of these sessions that you have in the future.
Thank you so much, sir. Your response has been very encouraging. Ms. Komal, are you there?
I'm there, but I'm afraid my audio is not working.
No, we can hear you. So your remarks, you have floor.
Oh, so can you guys finally hear me?
Yes, we can hear you. Miss, your voice is breaking again.
It's well, my closing remarks would be that arbitration is a fantastic area of law, and I would encourage everybody to at least study arbitration, to take part in arbitration, and it is very promising. So if there is anything which anybody wants guidance, I think I'm available, and Jawad has done a fantastic job by covering up. So thank you so much, everybody.
Thank you, Ms. Komal, and it's very unfortunate that we couldn't hear a lot from you, although our audience was really looking forward to it. But hopefully, inshallah, anytime soon, we might just get together, maybe in person. So thank you, Miss. Miss, your concluding remarks?
I think the three of my esteemed panelists have covered most of the legal aspects and the legal landscape. Firstly, I would like to again thank the Youth General Assembly for inviting us and for highlighting ADR. I would like to just add that ADR is just not for lawyers, and it's not for people who are doing undergrad degrees. In other countries, they have peer mediation skills being taught to even children, as young as grade 5. That culture should be something that should be developed in our countries. This alternate dispute resolution is not कि आपने litigation नहीं करनी इसलिए आपको skill set चाहिए होता है. The skills you learn in negotiation, in mediation, it helps you become a better person. It helps you have a better skill set. It helps you in your career as well, or in your personal relationships as well. It has an impact on your mental health as well. There are a lot of aspects to it. So it should be introduced not just in university, but even younger children should be taught this. Like, for example, negotiation, as Sir Jawad said, was only being taught to MBAs. Negotiation is a skill that everyone should have because it is required to lead a more successful life as well. So my concluding remarks are that yes, legally ADR is required because we have a backlog, but the skills that you learn in ADR, students should be taught those long before that. Thank you.
Thank you so much. My concluding remarks would be that there's still a long way to go, but there's hope with initiatives like the ADR initiative coming forward with independent practitioners like Ms. Kumar Anwar who are taking the lead. There is hope, and we hope that YG has done its bit in raising awareness about the very important topic of alternative dispute resolution. And for this, we're exceptionally grateful to our dynamic panel, Mr. Jawad Sirwana, Mr. Akbar Hussain, Ms. Mehik Zarak Bari, and Ms. Komal Anwar. It has been a duly enlightening session for me and hopefully for all the audience who tuned in and who will be tuning in future when we post a recording. Towards the end, I would also like to thank our partners, Quoting the Law, Kanun Dan, Games of Law, Women in Law Initiative, Adalar Sehat, and Center for Law and Justice for their support. Again, my warmest and most sincere gratitude to all our panelists. It was a great session. Thank you so much.
Thank you.
Thank you. It was a pleasure.
Thank you.
Allah Hafiz, everyone.
Bye-bye.
You, Allah Hafiz. Wow.